everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with working with sellers and what happens if a seller terminates a listing agreement early. What kind of early termination fees can you charge, and what does the listing agreement say? So that's what today's topic is. So first of all, in both the GAR and the RE listing agreements, and let me reference those for you. The RE Forms listing agreement is Form RE Form 151, and it is called the Exclusive Right to Sell Listing Agreement. And the GAR listing agreement is F101, and it is called the Exclusive Seller Listing Agreement. Very imaginative. Anyway, so in both of these listing agreements, there is a place to fill in the beginning date and the ending date. And it is a license law violation to not fill in the end date of a brokerage agreement. So you'll have to fill that in. There is no verbiage in either regarding terminating the agreement early, because it has an end date to the contract, and the contract is the listing agreement. Therefore, if a seller does choose to terminate the listing agreement early, the seller would be in default of the listing agreement. So the question is, what is the financial penalty, or what are the consequences if a seller chooses to default on the listing agreement by terminating early with the brokerage and not have that brokerage list the property anymore? Well, let's take a look at the forms and let's see what it says. So in the GAR listing agreement, under paragraph C1, it does have a paragraph on seller default, and it says, in the event the seller defaults under this agreement, which again they would by terminating early, the seller shall, in addition to its other obligations set forth elsewhere, herein reimburse the broker for the out-of-pocket costs and expenses incurred by the broker and the broker's affiliated licensees in seeking to market and sell the property. Such costs and expenses shall include, without limitation, printing, copying charges, mileage at the highest rate allowed by the IRS as a business deduction, and expenses to advertise the property in various media. Seller shall also pay all the costs, fees, and charges for removing the listing from any multiple listing service. The payment of these costs, fees, and charges and expenses by the seller shall not, however, waive or limit the broker's right to assert any other claim, cause of action, or suit against the seller for real estate commission or other damages, and shall not release the seller from such claims. Notwithstanding the above, the amount of the fees and charges and expenses paid by the seller to the broker shall be an offset against any claim of the broker for real estate commission. So that's the verbiage in the GAR purchase and sale agreement. In the RE form seller listing agreement, it also states, in paragraph 3 of the RE form listing agreement, it states, notwithstanding the payment of a retainer fee as provided above, seller shall reimburse the broker or broker's affiliated licensees for their costs and expenses incurred in marketing the property, including but not limited to printing costs, advertising fees, mileage reimbursements, and multiple listing fees. If seller defaults hereunder, the right to collect reimbursement for these costs and expenses shall be in addition to and not in lieu of any other claim, cause of action broker may have hereunder, except that these costs and expenses may be an offset against the commission paid to the broker. So definitely very similar verbiage. So in that situation, what should you do as an agent? How do you protect yourself? How do you collect these fees? Well, there are a couple of things to do. Number one is the MLS fees are charged to your broker. So they might change. So I'm not going to give a dollar amount here, but those are fees that the MLS has charged the brokers for withdrawing a property from the listing services before it sells or expires. And those fees are readily available. Regarding your marketing fees and your mileage fees, it's probably a good idea for you as an agent to keep track of all of that stuff per listing you take. That's really a good idea to do for your business anyway, to keep track of your business expenses. But especially if you are going to have a seller that for whatever reason terminates early, and you are going to, per this provision in the contract that they agree to when they sign the listing agreement, charge them for reimbursement of those marketing fees, you may have to provide an invoice, so to speak, or not really an invoice, but a listing of what those fees are that you incurred. Now, another way you can offset this is, and definitely get permission from your broker first, but there are many brokers and agents that charge an early termination fee that is a set fee for a seller terminating the contract early. And that would be a special stipulation that would be provided for in the listing agreement when the seller first contracts with the broker to have the property sold by that brokerage. So you might want to have an early termination fee as a special stip that would offset expenses. One of the other expenses, and this might be something to consider, is your time involved in the marketing. So there are the hard cost expenses as outlined in the agreement, such as marketing fees, printing fees, copying fees, mileage fees, so forth and so on. But your time is valuable as well. So that's why many brokers and agents do charge an early termination fee to account for their time involved in providing the valuable service of marketing the property for sale. So another way to address this is there is a retainer fee that you can collect from a seller, and there is a retainer fee exhibit that is a GAR form, and that form is GAR F-149 Retainer Fee Agreement. And this would be an exhibit that you would use to the brokerage engagement. You could use this for buyers or sellers, but specifically we're talking about the seller right now. And basically that says the way the retainer fee works, as whereas the client and broker have entered into a separate brokerage agreement or the agency agreement, and again that would be a listing agreement or a buyer brokerage agreement, this exhibit is part of that agreement. And it states that the client, which would be the seller in our particular example, would pay a retainer fee to the broker for the services in the amount of X amount of dollars, and you fill in the blank. This fee shall be payable in advance upon signing this agreement. The retainer is non-refundable and shall be held in the broker's trust account until, and then there are certain options that you negotiate with the seller. So it's trust money held by the broker, and it's non-refundable back to the seller, but it is not released to the agent until the client closes on real property utilizing the services of the broker in accordance with the agency agreement, the end of the agency agreement, or the mutual termination of the agency agreement by the parties. And there's a little bit more verbiage in there, but take a look at that. Now, I know what some agents might do is they might have a non-refundable retainer fee that the seller pays at the time of listing. And then upon the successful closing of the property, some brokers are giving that as a credit back to the seller against the commission. But if it fails to close, then the broker can take it from the trust account and either keep it or pay it to the agent to offset their expenses. So that's something to take a look at. Now let's talk about the actual termination of a listing agreement. So if a seller signs a listing agreement with the broker and it just expires, that's one thing. But to terminate the agreement prior to the expiration date of that agreement, if you're going to terminate it in the RE forms, you're just going to use just a general amendment to amend the brokerage engagement and discuss the terms of the termination. In the RE forms, in the GAR forms, GAR has provided for us two forms that you can use. One is F-152, and that is a mutual termination of a brokerage agreement. And the other form is F-155, and that is a unilateral termination of the brokerage agreement. So let's talk about the unilateral termination first. That is a form where either the broker may unilaterally terminate the brokerage engagement with the seller, or the seller or buyer, this is a brokerage engagement, may terminate it. The termination can be done by the client or by the broker. And in these forms, there is verbiage about when the effective date of the termination is, and it states that in terminating the agreement, the broker is directed by the client not to perform real estate brokerage services on behalf of the client after that date of the termination. Nothing herein shall be construed as an agreement between the client and broker to mutually terminate or to limit, waive, or terminate the broker's rights to commission or the reimbursement of fees and costs resulting from the unilateral termination. So in other words, a broker may be fired from representation, but not necessarily compensation. So a unilateral termination is just a notice of termination, but does not necessarily alleviate that seller from any commission or fees due the broker for the services that have been provided by the broker. Now, the mutual termination of the brokerage agreement, again, this is GAR form F-152. This is a little more, has a little more information that a broker and a client negotiate through. So it's a mutual, so the unilateral one obviously only requires either the broker or the client's signature. On the mutual termination, it is mutual, therefore it requires both parties' signatures. And you do specify which brokerage engagement you're terminating, the listing agreement or the buyer brokerage. And then it says, upon the mutual termination of the agreement, the parties shall have no further rights or responsibilities to one another other than the following, which the parties agree shall survive the termination. And then there are check boxes where you guys negotiate through what shall still survive the mutual termination of the brokerage agreement, listing agreement or buyer brokerage. The protected period either shall or shall not stay intact. Simultaneously with the execution of the agreement, the client shall pay the broker X amount of dollars to reimburse the broker for their fees, costs, and expenses, again, relative to that paragraph we read at the beginning of this video that's outlined in the actual client acknowledgement, the brokerage engagement. Then there's another item to negotiate through that says the client shall pay the broker X amount of dollars in full and final settlement of any and all claims, causes of action, suits, and damages of the broker arising out of or relating to the agreement. And then there's a place to negotiate through any other finances that the broker and the client want to negotiate through. So I just wanted to bring to your attention some of the issues regarding a client. In this specific case, we've had some questions about a seller terminating the listing agreement early. So I just wanted to let you know what is in the actual listing agreement that the client signs at the time you take the listing, what it says about reimbursement, and then as an agent, some things you can do to follow through with that, that we have addressed, and then the forms that are available to you to actually terminate the listing agreement. Thank you guys. Hopefully you never have to use this. Hopefully you list a property and it sells and everybody is happy and it's wonderful, and that's what we're here to do, is help people with their real estate needs. So hopefully none of this will ever come into play, but I did want to bring your attention and awareness to what is available for you in the contract forms. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.